Hey, change your mountain, Jinchang. Oh, okay, back again.
It looks like background is very, the color is very deep.
It's all right. It's very calming, actually. Okay, so we have 1 minute and we have close to 150 participants. We will start at 9. Attorney Elaine.
And somebody asked if we are recording the meeting.
Yes, Jincha, I will record it.
Yeah.
It's 9 a.m., so good morning, everyone, and welcome to the first of a four-part webinar series on Republic Act number 11057, otherwise known as the Personal Property Security Act or the PPSA, organized by ACCRA Law in partnership with the International Finance Corporation, a member of the World Bank Group. I am Elaine Reyes Rodolfo, a partner in the Corporate and Special Projects Department of ACCRA Law, and I will be your host and moderator for this morning's webinar. We are excited to see so many participants from various stakeholders in this session, some of which are our very valued clients. Thank you for making the time to join us this morning. This webinar series is being launched as part of ACCRA Law and IFC's collaborative and continuing efforts to deepen and strengthen our collective understanding of the PPSA, a transformative law that aims to modernize the secure transactions framework in the Philippines. As we all know, the PPSA lays the foundation for using personal property as collateral in a manner which facilitates broader access to debt, particularly for the micro, small, and medium enterprises. And today, we are very fortunate to have with us a globally recognized authority in secured financing who will share with us his insights into the legal foundation of the PPSA. It is my privilege to introduce our speaker today. Mr. Bruce Whittaker is a senior fellow at Melbourne Law School, University of Melbourne in Australia. He spent the majority of his professional career as a legal practitioner in Ashurst, one of the world's leading commercial firms, spending 25 years as a partner in the firm's finance team, where his legal practice spanned both domestic and cross-border finance, including secured financing. Mr. Whittaker was actively involved in the comprehensive rewrite of the Australian Secure Transactions Law that was implemented by the enactment of the Australian Personal Property Securities Act of 2009. In 2014, he was also appointed by the Australian Attorney General to conduct a review into the operation of the Personal Property Securities Act 2009 and to make recommendations for reform. The Australian government recently released draft legislation to implement a great majority of those recommendations. Outside Australia, Mr. Whittaker has been the Australian delegate to both the United Nations Commission on International Trade Law and the International Institute for the Unification of Private Law on a range of projects related to secure transactions law reform. He has played and continues to play a leading role in the drafting of a number of instruments, including the UNCENTRAL's model law on secure transactions, to which our PPSA was patterned. Mr. Whittaker has also worked on a range of projects, including with the World Bank Group, for the on-the-ground implementation of secure transactions law reform in developing countries, including the Asia-Pacific region. A very warm welcome to our distinguished speaker, Mr. Bruce Whittaker. Bruce, the floor is yours.
Thank you very much, and thank you also for that warm welcome and introduction. I hope everyone can hear me. We have a lot of people on the webinar today, which is tremendous. I just hope that my internet connection is able to stand up to the task. So could someone share the slides, please? There we go. We perhaps should go to the first slide, if we could. There we go. Thank you. So today is the first of 4 webinars that have been organised in relation to your Personal Property Securities Act. Today, I'm going to talk about the foundations of your PPSA and its scope. In the second webinar, we'll talk about the rules in the PPSA for creating and perfecting security interests. In the third webinar, we'll talk only about the registry. The registry is very much the foundation stone of all PPSAs, including yours. I think it's worth spending an entire webinar talking just about the operation of the registry. And then in the fourth webinar, we'll talk about the priority rules for dealing with competitions between security interests under the law. We'll talk about how you enforce security interests under the law. And if we have time, we'll talk a little bit about the transitional rules that explain how you go from where you have been into the way the law works. Next slide, please. So in today's webinar, I'm going to talk about 4 things. I'll start by talking about the objectives of the PPSA. That is background to the law rather than the language of the law, but with a law like this, you can really only understand the law if you understand what it's trying to do and where it comes from. So I'll start by talking about its objectives. I'll talk about the international context from which your PPSA has come, and you've already heard mention of the UNCITRAL model law and secure transactions, and we'll certainly come back to that. I'll then talk about the key principles that legislation like your PPSA adheres to or attempts to adhere to in trying to achieve its objectives. And then finally, we'll start to get our hands dirty, if I can put it that way, by delving into some of the language of the law and in particular into a couple of the most important definitions or concepts in the law that help to define the scope of its operation. Next slide, please. So what's the law about? In a nutshell, the law is all about access to credit, or in particular, providing greater availability to affordable credit. Next slide, please. That was a quick one. In many countries, and many studies, including by the World Bank Group, have demonstrated this. In many countries, one of the main reasons why businesses are unable to grow and reasons why economic growth is being held back is the fact that businesses, and in particular small to medium-sized enterprises, are unable to get sufficient access to affordable credit. Now, lenders will know that a lender will normally only be prepared to make a loan if they're confident that they can get their money back. And one of the ways in which lenders like to ensure that they can get the money back is by taking security for the loan. And traditionally, lenders prefer to take security over land. Lands in many jurisdictions is sometimes the only asset that you can easily take security over. Unfortunately, though, most small to medium-sized enterprises don't own land. They will own assets. They will often be valuable assets, but often the laws of the land don't make it easy for businesses to use those types of assets as collateral. Countries will often have a patchwork of laws which provide some rules for using particular types of assets as collateral for loans, but they won't have comprehensive laws. Those laws will be of a patchwork nature. Often they'll be very old and out of date and no longer reflect modern business practices. And sometimes those laws will even be inconsistent with each other, which makes it then very difficult for lenders to navigate the legal framework that they need to work with in order to provide finance. And all these sorts of reasons put lenders off being prepared to provide finance, which means it's harder for businesses to get access to credit. Next slide, please. Laws like your PPSA are designed to deal with exactly this problem. Helpfully, your PPSA actually goes to the effort in Section 2 of explaining this by saying this the policy of the state, and I think by implication the policy of this law, to promote economic activity by increasing access to least cost credit, particularly for micro, small and medium enterprises. That's one of the guiding principles that underpin all of the PPSAs, but I think it's actually very helpful that your law has gone to the effort of making that clear. Next slide, please. Now, the way laws like the PPSA do this is that they replace that patchwork that I've just described of limited, sometimes inconsistent and out-of-date laws with one law that provides a unified, internally consistent and efficient set of rules that cover the entire range from cradle to grave of security interests. So they provide rules that explain how you create security interests. They explain how you make those security interests
Sorry, Bruce, you muted. Please unmute.
Can you hear me now?
Yes, we can hear you now. Thank you. Please continue.
I don't think I touched anything, so I'm sorry. I don't know why I went on mute there. At the risk of repeating myself a little bit, then I'll say that laws like the PPSA achieve this objective by providing a new modernised set of rules for the entire cradle to grave of security interests. So how you create them, how you make them effective against third parties, how you resolve priority competitions between security interests, and also to some extent between security interests and other common types of interests in collateral. And then finally, they provide an efficient and clear set of rules for enforcing security interests. Next slide, please. Now, the Philippines is not the first country to go down this path. You're now one of over, I think, 130 countries that have gone through our reform process along the lines of your PPSA. Different countries do it in different ways, but over 130 countries have made efforts to modernise their secured transactions laws along these lines. And they include a lot of common law countries, such as my country, Australia, Canada, New Zealand, Papua New Guinea, one of your near neighbours, Brunei. And it also importantly includes civil law countries, such as Colombia and Peru in South America, Nepal and Egypt in other parts of Asia, and one of your near neighbours, Timor-Leste, has in fact just finalising its process of enacting a secure transactions law along the same lines as your PPSA. So a lot of countries have done this, and I think that's going to be helpful for you because that international context and the fact that so many other countries have done it will provide you with a source of guidance on how to go about interpreting your PPSA. And certainly that's been the experience in other countries. When they've enacted a PPSA, they've looked overseas to see how other countries have applied it to help them to work out how to apply it themselves. Next slide, please. Now, the original source of all PPSAs is Article 9 of the Uniform Commercial Code in the States, first enacted in the States in the 1950s. As you've heard, those principles have been adopted, albeit using rather different drafting, in very many other countries around the world. And the principles that derive from Article 9 have also been adopted in model legislation and guidance materials by a number of international organisations, in particular in Africa, in Asia, and also in South America. Now, the most recent expression of best practice for secure transactions laws comes from the United Nations through its subsidiary body, the United Nations Commission for International Trade Law. And those principles are expressed for the most part in the Model Law on Secure Transactions, which was adopted by the UN General Assembly in 2016. That model law is also supported by quite a significant amount of guidance materials, in particular the Guide to Enactment, which was adopted in 2017 and which is principally, but not exclusively, a guide for legislators who are contemplating enacting a law along the lines of the model law. Now, I say principally because there's a lot of material in the Guide to Enactment that is very useful for people who are trying to interpret and apply the law as well. But then ACCRA also produced a more specific practice guide in 2019, which is addressed particularly at judges, lawyers, business people who are trying to work out how to work with the model law around secure transactions and how to make most value out of the opportunities that it provides. And whilst all of the overseas materials are helpful, I think the model law on secure transactions is going to be particularly helpful for you in coming to grips with your PPSA, as we'll discuss as we go through the rest of this. Next slide, please. Now, I've worked with Jin Chung.
Oops, you got muted again, Bruce. Sorry, just now.
I do not know why that's happening. I'm sorry, but thank you for letting me know. So I've worked with Jin Chung and his colleagues at the IFC on reform projects in the area of secure transactions law in a number of countries around the world, including here in Asia. But as you heard in the introductory remarks, I think my primary credential for being able to talk to you today about your PPSA is that I worked as a banking and finance lawyer in Australia when we went through exactly the same reform process as you've been undertaking, which we did about 15 years ago with our Personal Property Securities Act. Similar to what's happened for you in the Philippines, that act in Australia effectively threw out the door all of the rules that I'd spent most of my career working with as a banking and finance lawyer and replaced them with an entirely new set of rules. Dealing with the PPSA became the mainstay of my practice at that point. I spent about the last decade of my career not only working out what that meant for us as a law firm in terms of our precedents and our procedures, but also advising many of our clients on what it meant for them. So what they needed to do to their documents, what they needed to do to their procedures, how to understand what the law actually meant for them, but also importantly to work out how they could benefit from the new flexibilities that the PPSA provided to them. And one thing I learned particularly through that process was that implementation of a law like the PPSA is never straightforward, not in any jurisdiction. You need to come to grips with entirely new concepts. You need to understand new terminology. You need to develop new practices, new documents and new procedures. So for the entire legal profession, it's very much going back to school and doing a lot of starting again. It is, I will say, for everybody often very hard to shake off traditional legal thinking, sort of trying to turn your brain on its head, if I can put it that way, and look at things from an entirely different light. But to some extent, to understand the PPSA, you need to do exactly that. And that will become apparent, I think, if not already, as we go through today and the other three webinars. Next slide, please. That's, I think, probably enough for the time being, at least about the international context. Now I want to talk briefly about how it is that the PPSA goes about its objective of increasing access to affordable credit. And it does this through 4 guiding principles. The first of those principles is that the law, to be as effective as possible, needs to be as comprehensive as possible. It should apply to security interests over all types of property other than immovables or land, and it should apply to all types of arrangements in which an interest in that collateral is used as security for finance. The second principle is that the rules that it provides should be consistent, clear, and logical. So one of the objectives of the law is to do away with, as far as possible, with all the uncertainties that were there in the application and interpretation of prior law, and provide a clear, consistent, logical set of rules that initially at least will be unfamiliar, but are clearly and carefully structured so that they work well together. And this, it will all facilitate the provision of secured finance because it removes a lot of that uncertainty. Lenders hate uncertainty. If there's risk, if there's uncertainty, lenders are less inclined to lend. So the more you can eliminate uncertainty and make things clear, the more confident lenders will be to provide finance. So it removes uncertainty, but also being a modern best practice law, it will also, as much as possible, be able to reflect modern business practices and modern expectations, but in a way that's flexible enough to accommodate new developments in financing techniques as they are developed. In doing all of this, though, it does still need to be careful to strike a balance. Clearly, you want to make it easier for lenders to lend confidently, but you don't want to do that in a way that unfairly prejudices borrowers. So you need to strike a balance between the interests of the lenders on the one hand and the interests of their customers and third parties on the other. And again, certainly when the model law on secure transactions was being drafted, an enormous amount of effort went into making sure that the rules struck that appropriate balance. And then finally, the fourth guiding principle is that within all of that context, the law should be as simple as possible. The law will never be a simple law because secured finance in the world of finance is not simple. So you can't expect to have really simple laws that will help the business of secured finance work efficiently, but you should strive to keep those laws as simple as possible. And that includes removing as many unnecessary formalities as possible from the process of taking security over assets, and as far as possible, keep it as simple, clean and straightforward as you can. Next slide, please. So that's enough on the preliminaries. I'd now like to talk about the actual language of the law for the balance of this webinar this morning. And what I'd like to start by talking about today is the scope of the law. So what does the law apply to? And given that the law is called a Personal Property Security Act, it's no surprise to know that the two key concepts within the law are, on the one hand, what is personal property, and in particular, what does personal property mean for the purposes of the PPSA? And secondly, what is a security interest? Again, for the purposes of the PPSA. These two concepts are clearly underpin the way the law works as a whole, and they also establish the outside parameters of the law, of what the law actually applies to. Next slide, please. Now, being a lawyer, I'm going to have to start the detailed discussion, I'm afraid, with a bit of a disclaimer, which is I am not admitted to practice in the Philippines. So I can't tell you exactly what the law means in the context of broader Philippine law. Ultimately, the meaning of terms personal property and security interest, and indeed the meaning of the law as a whole, is going to fall to be determined by your judicial system, by your judges, read in the context of Philippine law as a whole. I'm not admitted to practice in the Philippines. I wouldn't dare to try and prescribe to you exactly how your judges will approach the law, but I can tell you what I think these terms are intended to mean. I can tell you what I think the law is trying to say and trying to do, looked at particularly from the international context from which it comes. Next slide, please. So turning first to the concept of personal property. Now, the Act itself, I don't think, defines personal property, which means you need to look to your other law for the meaning of the term, which I believe is going to be your civil code, in particular around Articles 416. As I said, I'm not a Philippine lawyer, so I'm not going to try and tell you exactly what those articles mean, but my expectation is that the concept of personal property for the purposes of your PPSA should cover all forms of property that are known to Philippine law other than immovables, the ones that are excluded expressly by, I think it's Article 416, 415, and the neighbouring provisions. Interestingly, even though it's called a Personal Property Security Act, the law doesn't actually use the term personal property very often. It uses it in the preamble and then again in Section 2, but for the most part, the Act refers instead to the term collateral, which again, I think is also not defined. I think it's reasonably clear that when the Act talks about collateral, it is talking about personal property, as you understand it, that is subject to a security interest. Next slide, please. Then just to set the context a little bit, to give some examples of what personal property could be. Tangible property, vehicles, factory equipment or tradesman's tools, consumables in a manufacturing process, inventory for a manufacturer or a wholesaler or a retailer. Examples of intangible property, and I'll come back to this in a second, accounts receivable, other rights under contracts should all be intangible property. Company shares or intellectual property, again, are examples that are commonly expected to be covered by a concept of personal property. Now, two I just wanted to dwell on a little bit or highlight are inventory as an example of tangible property, and then accounts receivable as an example of intangible property. I mentioned earlier that most small to medium-sized enterprises have struggled to raise credit in the past because they haven't got land that they can offer up as security. One thing that many smaller businesses do have, though, are inventory and accounts receivable. If you're a manufacturer, you make inventory, you have it sitting there in the warehouse before you've sold it. When you do sell it, often you'll sell it on deferred payment terms, which means you no longer own the inventory, but now you own an account receivable. For many small to medium-sized enterprises, that inventory and those accounts receivable are their most valuable assets. So it's really, really important to have a secure transactions law that facilitates the use of those types of assets as collateral. Now, your PPSA certainly does that. We won't discuss that in much detail today, but we'll certainly come back to that in later webinars. Next slide, please. There are two exclusions from your definition of, or your concept, I should say, of personal property in Section 4. Aircraft subject to your Civil Aviation Authority Act, and ships subject to your ship mortgage decree. I understand that to be because you have separate mortgage registration systems under that legislation for aircraft and ships. Now, from a sort of policy perspective, it's not always necessary to actually exclude aircraft and ships from a PPSA regime. It's entirely possible to accommodate security interest over aircraft and ships within a Personal Property Securities Act. That's what we did in Australia. So our Australian PPSA does apply to both aircraft and ships, and that actually provides you with greater flexibility for aircraft and ship financing, I think, than if you simply have to rely on the mortgage systems in that other legislation. Having aircraft and ships covered by different legislation can generate some consistency challenges in trying to manage the interaction between that legislation on the one part and the PPSA on the other, but you have kept them out of the PPSA, and that's just a challenge that you'll need to deal with as you go along, and we can perhaps touch on some of those challenges in the later webinars as well. Next slide, please. So that's enough for the time being on personal property. As I said, it's not defined by the PPSA, so that will mostly fall to you as Philippine lawyers to work out what that means in the context of the balance of Philippine law. The term security interest, though, very much is defined in the PPSA. And that definition in Section 3J has two parts. I won't read them out for you. They're up there on the screen, and no doubt you've seen them in the legislation as well. Now, whilst your Act doesn't specifically describe them in these terms, it is common to refer to the two parts of the definition as being an in-substance security interest part, which is at the top of the screen, and then a deemed security interest part, which is the language at the end of the definition. And I'll talk you through the distinction between the two and the implications of the two as we work our way through the rest of this morning's session. Now, I think we can move to the next slide because I've extracted the key parts of those definitions in a later slide. Before we get to that later slide, though, it is worth drawing your attention also to section 4, which underpins at least one of the concepts that go into the in substance security interest part of the definition. And that's the section that says that the Act applies to transactions in any form that secure an obligation with movable collateral. Now, this emphasises the point I made earlier about the law needing to have an application that is as comprehensive as possible. Most traditional legal systems, both civil and common law systems, generally rely on the legal form of a transaction in order to determine its legal consequences. So in common law systems, for example, the only real exception to that is where a transaction is a sham. In other words, parties have called it one thing, but they actually intended it to be something entirely different. Section 4 tells us that that traditional rule doesn't apply when you are interpreting your PPSA. So rather than allowing the form of the transaction to dictate its legal consequences, the section says that the Act applies to all transactions of any form that secure an obligation with movable collateral. And as you'll see when we dig into the detail of the definition of security interest, in deciding how to apply this, you don't look any longer at the legal form of the transaction, but rather you apply its commercial substance. You look at the commercial effect of a transaction in order to decide whether or not the Act applies to it as a security interest. Next slide, please. Before I get into the detail of the language of the definition, I thought it would be helpful just to compare the text of your definition, at least the in substance security interest part, with the language that is in the corresponding definition in Unsworth model law on secure transactions. And as you can see, apart from some terminology differences, the two definitions are almost exactly the same. I said earlier that the model law on secure transactions and its guidance materials would be helpful for you in interpreting your PPSA, and this is possibly the best example of why that's the case. You have used clearly the model law on secure transactions definition, and that hopefully means that you and your judges, whilst you obviously won't be bound by the Unsworth guidance materials, you'll certainly be able to look to those materials in order to help you to understand what the definition is trying to say. Next slide, please. So clearly, as I said, the definition comes from the model law on secure transactions. There was one bit missing, you will have seen on the previous slide, which is the reference to, in the model law on secure transactions, to the interest having been created by an agreement. You don't have that in your definition of security interest, but you do say that anyway in section 5. So I don't think the fact that those words are missing make any difference to the way you should go about applying your legislation. Now, I said that hopefully, no, I haven't quite got to that one yet, that hopefully you would be able to use the MLST guidance materials in interpreting your law. As I said, that's been done in many other countries overseas, particularly in the early days of applying the new legislation. Courts and legal advisors have regularly looked to the way similar legislation has operated overseas, not because the overseas decisions are binding, but because they provide a bit of a leg up in helping you to understand what it is that the legislation is trying to do. Then as jurisdictions develop more of their own legislation, they start to look less and less at what people said overseas and are able to rely on their own jurisprudence in working out how to apply the law. But certainly in the early years, having the overseas support is really, really very important. Next slide, please. So breaking down the text of the definition a bit, the first key component of the definition that something is only a security interest if it's a property right in collateral. Now, it's very important that it needs to be a property right. Whether or not it is a property right, again, is something that will need to be determined by your general principles of law as to what or is or is not a property interest. One thing that is important to know, because this question does tend to come up a lot early on in jurisdictions that enact a PPSA, is that a guarantee is not by itself a security interest. But certainly, yes, in a colloquial sense, a guarantee secures performance of an obligation because it gives the lender another person that they can turn to for payment of the obligation if the primary obligor doesn't come up with the money. But that does not make it a security interest, because a guarantee at the end of the day doesn't give the lender a fresh interest in an item of collateral. It simply gives the lender another person they can go to for payment of the debt. So first thing to know is it needs to be a security interest, it needs to be a property right. The second component of the definition is that property right needs to secure payment or other performance of an obligation, and that's regardless of the type of obligation. So almost always the obligation is going to be a payment obligation. So probably 99% of security interests secure an obligation to pay money. But it doesn't necessarily have to be the case. There can be security interests that secure the performance of some other type of obligation. So in project financings, for example, banks will often take security not just to secure payment of a debt, but also to secure step-in rights to allow them to step into a project and take over the conduct of a project if the project company is not performing its obligations to the bank. So almost always the obligation being secured will be a payment obligation, but that's not necessarily the case. The third point to be aware of is that an interest will be a property interest if it fits the other aspects of the definition, regardless of what the parties have called it. Terminology does not define whether or not something is a security interest. You look through the terminology and examine the substantive effect of the transaction. If the substantive commercial effect of a transaction is that the financier has a property interest in collateral that the financier is using to enhance its ability to recover the money that's owed, then probably that interest is going to be a security interest, regardless of what it looks like under traditional legal thinking. The fourth component of the definition is that the definition applies regardless of the type of asset. This comes back again to that point I made earlier about the comprehensive nature of a good secure transactions law and the comprehensive nature of your PPSA. The rules in the Act apply to all types of collateral, to all types of personal property that are covered by the Act. And as far as possible, those rules should apply in exactly the same way. There will be some situations where you do need slightly different rules for particular types of collateral just because of the nature of the collateral. But unless you have a specific situation like that, the rules should be the same for all types of collateral. And then finally, the rules should also apply to all types of grantors and all types of secured creditors. So you don't have specific rules for finance provided to banks on the one hand. You don't have specific rules for grantors who are natural persons rather than companies. As far as possible, the rules should be exactly the same for all types of grantors and all types of secured creditors. Again, there will be circumstances where that's simply not practicable. And you'll see when we come to our discussion of the registry, for example, that clearly you need slightly different rules for how you identify natural person grantors as opposed to corporate grantors in the registration system. But subject to those exceptions, the rules should be the same for absolutely everybody. Next slide, please. Actually, let me say in the slide, one thing I should have mentioned is that one consequence of this is that you can continue to call your security interests by their old terms if you want to. You can continue to call something that used to be a chattel mortgage, you can keep calling it a chattel mortgage. The fact that you call it a chattel mortgage, though, has no consequences for the purposes of the operation of the PPSA. It will be a security interest, and the rules that you need to apply to it will be the rules in the PPSA, not whatever general law rules or legislative rules might have applied to chattel mortgages in the past. Indeed, in many jurisdictions, drafters now don't even bother to use an old law term for their security interest. They just say that the grantor grants a security interest to the secured creditor. And for the purposes of the PPSA, that works absolutely perfectly well. So turning into some examples of what we mean by security interests, clearly it's going to apply to things that your existing law already thinks of as being a security interest. Pledges, chattel mortgages, assignments by way of security. Pledges clearly previously were covered by provisions in your civil code, which I believe have now been repealed by section 66 of the Act. That's as a bit of an aside. It's great that you've done that. In other civil law jurisdictions, that's been a more challenging issue to deal with because of the very high regard in which the civil code is usually held in civil law jurisdictions, and various arms of government particularly have been loath to expressly amend their civil codes to deal with the fact that the PPSA provides different rules for pledges to the ones that have been previously in the civil code. Where you don't expressly amend the civil code, then you are left with a bit of an uncomfortable uncertainty as to how you deal with that interaction. So I think it's great that you have actually gone to the effort of amending your civil code to remove that inconsistency. Chattel mortgages is another example of that. I think you did previously have a chattel mortgage law dealing with chattel mortgages. Again, I think that's been repealed by section 66, so that removes the risk of inconsistency and uncertainty in how you go about applying the PPSA to what previously would have been called chattel mortgages. Also, I think standard assignments by way of security have been a regular feature of secured financing practice in the Philippines. There are some provisions, as I understand it, in the Civil Code that deal with assignments by way of security. They, I think, have not been repealed. So there is a bit of a risk there of inconsistency in how you, in deciding what rules you apply to assignments by way of security. But hopefully your PPSA also includes, I think it's a section 61, which says that in the case of conflict between the application of the PPSA and the application of other law, the PPSA prevails. So hopefully your judges will read section 61 as having the effect that for the purposes of assignments by way of security, you now apply the rules in the PPSA and not the rules that previously applied under the Civil Code. Next slide, please. So they're the easy ones, traditional security interests. The more difficult ones, though, are the types of interests that traditional law, your law previously would not have considered to be a security interest, but now fall within the definition of that term in the Act. And the types of interests which always generate the most difficulty for every country that reforms their laws along the lines of the PPSA is what are often called title-based security interests, or sometimes called quasi-security interests. The most usual example of these are finance leases and situations where a manufacturer or a distributor sells goods on a retention of title basis. Now, this issue arises because, again, the definition of security interest ignores the legal form of a transaction in deciding whether the definition applies and looks instead at its economic substance. So it captures any situation where a person uses ownership, an interest in an asset, which could include ownership of the asset, as a mechanism for ensuring that they recover an amount of money that they are owed. In some jurisdictions that enact a PPSA, they actually try to clarify this by expanding the definition of security interest to give some examples of what is covered by a security interest, and they will include things such as finance leases and ROT sales in the definition itself, just to put the point beyond doubt. Your definition doesn't do that, but despite that, it's clear, and I think that arrangements such as finance leases and ROT sales will be covered by the Act. Next slide, please. And just to give you an example of the logic that sits behind this, and this is an example that applies to finance leases. I won't try and read it all out a little bit. Let's take an example of someone who's a baker and they need a new delivery van. Traditionally, the bank may well provide finance to Alberto by lending him the money. Alberto buys the van, bank takes a chattel mortgage over the van to secure repayment of the loan. That's one way banks can do it, and one way banks commonly do still do it. A different way the bank could have done it, though, would be by way of a finance lease. So rather than lend the money to Alberto to buy the van, the bank could itself buy the van and then lease it to Alberto. Typically, the rental stream under the lease is structured in exactly the same way as the repayments would have been structured under a secured loan. It's just it's structured as a lease rather than as a loan. From the bank's perspective, though, both transactions are economically identical. In both cases, the bank is taking an interest in the van, not because the bank wants to own vans, but rather the bank is taking an interest in the van in order to enhance its prospects of recovering the amount of money that it's owed if Alberto defaults on the repayments. So economically, the two transactions are exactly the same, and for that reason, the PPSA treats them in exactly the same way. Now, next slide, please. The same approach then applies to sales of goods on retention of title terms. This is a technique that I believe is also common in the Philippines. So if a manufacturer sells its goods to a buyer, it might give the buyer 30, 60, 90 days to pay the amount of money that they're owed for the purchase of the goods. The manufacturer's trade terms will typically say that even though we've given you possession of the goods, we retain title to the goods until you pay them for us. That's a very common practice, certainly in many countries around the world. Now, the manufacturer is not retaining title to the goods because they want the goods back. They don't want the goods back at all. They want the buyer to keep the goods and sell them and then pay the purchase price. The manufacturer is only retaining title to the goods in order to enhance its prospects of recovering the amount of money it's owed, because traditionally, in theory at least, the manufacturer, if not paid, could repossess the goods because it's the owner of the goods and then just go and sell them to somebody else and get the money that it wants that way. Again, because the manufacturer is only retaining title to the goods not because it wants the goods back, but in order to make sure it gets paid, that retention of title arrangement is a security interest for the purposes of the Act and is then regulated by the Act as a security interest. Now, the fact that ownership of the asset is characterised by the Act as a security interest is in almost every jurisdiction conceptually one of the hardest parts of the PPSA for operators to grasp. It's very counterintuitive. Certainly in common law jurisdictions, we're very much brought up on the concept of nemo dat quod non habet. A person can only give that which they have, and the theory always was that if you own an asset, that gave you a pretty unassailable right to defend that asset against claims from third parties. That under the PPSA is no longer the case, at least as far as the operation of the PPSA itself is concerned. If your ownership in the asset is operating as a security interest, then that is how it is treated by the Act. Next slide, please. So what this means is within the PPSA, at least, ownership is no longer the protection that it once was. You as the lessor think you own the asset, but for the purposes of the PPSA, you are only treated as if you have a security interest in the asset, and your lessee even though on general law principles they are only a lessee, they are treated by the Act as if they own the asset and had given a mortgage over the asset back to you as the financier. Now, this is relevant for the operation of all parts of the Act, including in relation to how you register security interests, but it's particularly important for the priority competitions, and it's particularly important when you come to working out how to enforce your security interest on default. And we'll talk about both of those in a later webinar. Next slide, please. We'll then come on to the last part of this morning's discussion, at least from me, and that's to talk about the second leg of the definition of security interest in Section 3, which is what I referred to earlier as being the deemed security interests. So this is the part of the definition that says that the definition includes the rights of a buyer of accounts receivable. It also includes the rights of a lessor under an operating lease for at least a year. And these two legs of the definition apply and operate independently of the bulk of the definition of security interest. So they apply whether or not the rights of the buyer or the rights of the lessor can be said to secure an obligation. Now, this often generates a bit of consternation for people who are trying to come to grips with the PPSA for the first time, because it's meant to be a Personal Property Security Act, and yet you're extending it to a couple of relationships that don't actually involve the taking of security. And I will try to explain the thinking that lies behind the decision to do that. Next slide, please. So looking first at the definition, the first leg of that, which is the right of a buyer of accounts receivable. Again, as you can see, this has come pretty much word for word from UNCITRAL's model law on secure transactions. So again, you'll be able to use the MLST guidance materials as hopefully a source of inspiration for understanding the implications of the fact that the Act applies to outright transfers of receivables. Now, perhaps I should have made that a little bit clearer when I said that it applies whether or not the transaction secures an obligation. What that means is that the law applies both to transfers of accounts receivable by way of security, but also to outright transfers of receivables where there is no security function at all and the buyer is genuinely just buying the receivable. That outright transfer will be a security interest, or will give rise to a security interest under the law, and the law will apply to it in the same way as it would apply to a transfer by way of security. Next slide, please. So the term, I don't think the term accounts receivable is actually defined in the Act. I'm not sure whether that's a generally understood term more broadly under your law. Helpfully, though, there is some guidance given as to what it might mean in Section 10D, which again is a section we'll come back to in a later webinar. And that section makes it clear that accounts receivable can arise under contracts for the supply or lease of goods or services, other than financial services, construction contracts or contracts for the sale or lease of real property, and contracts for the sale, lease or license of intellectual property. I mentioned, so let me start that sentence again. I want to focus a little bit there on the first of those three, which is the one that usually has the most practical importance for PPSA regimes, and that's receivables that arise under contracts for, in particular, the supply of goods or services. I've talked a little bit already about manufacturers who manufacture goods and then sell them on 30, 60 or 90-day deferred payment terms to people. That debt that's then owing to the manufacturer is clearly going to be an account receivable under that first limb there about it being a contract for the supply of goods. Similarly, if you are an electrician or a plumber and you do a job for a customer and then you send them a bill, the amount that you're then owed under that bill is going to be an account receivable because it arises under a contract for the supply of services. Now, as I've said, for many small businesses, those types of debts, those types of accounts receivable are often the most valuable asset they have. And it's very helpful for them if they want to raise credit for their business, if they can use those receivables as collateral for finance. And as we'll discuss in later webinars, that is one of the things that the PPSA does very well. Next slide, please. Now, as I said, people often scratch their heads and go, well, why are they applying a law about security to outright transfers of accounts receivable? And there are usually three reasons that are given for doing this. The first of those is it's often actually very difficult to work out whether a transfer is an outright transfer or a transfer by way of security. I think businesses such as finance companies or factoring businesses are very active in the area of taking receivables as security for finance. Sometimes they will, as I said, take security over a pool of receivables. Sometimes they will take the receivables as an outright transfer. Very often, though, the transactions are highly structured and provide for varying levels of recourse that the financier can have back to the customer if the obligors on the receivables don't pay them when due. And because of that variability in the way these transactions are structured, it can often be very difficult to say whether a transfer of a receivable is an outright transfer or whether it's a transfer by way of security. And one of the things the PPSA does is it takes that uncertainty away by simply applying the law to all types of transfers of receivables, both outright and by way of security. The second reason why outright transfers are included is that it would be really difficult to, in fact, it wouldn't be possible to apply meaningful priority rules if you have a competition between two interests in transfers and the law applied to some of those interests but not others. So to give an example, if I first transfer a receivable by way of security to a person and then I transfer the same receivable outright to a different person, if the law applies to the first of those transfers but not the second, then the law can't provide you with a meaningful priority rule to work out which of those two transfers takes priority. So by applying the law and its priority rules to both of those transfers, the law removes that uncertainty by providing a clear rule. And thirdly, this is perhaps not so important for you, but is certainly important in many jurisdictions, is by applying the Act to all types of transfers, it does provide you with a clear, consistent and certain set of rules for how you both make all types of transfers and how you then enforce them. So for those three reasons, it is almost always the case that PPSAs or other laws based on the model law and secure transactions will apply to all types of transfers, including outright transfers. And again, we'll discuss some of the practical consequences of that in the later webinars. Next slide, please. Just talking now initially about a couple of practical consequences of extending the Act to all types of transfers of accounts receivable is again means that ownership of a receivable is no longer the protection that it used to be. So traditionally, if I buy a receivable outright, it's now mine. The transferor no longer has any interest in it. For the purposes of the PPSA, though, that's no longer correct. So the PPSA will recharacterise that transaction as a security transaction. And if the buyer wants to protect its position as buyer of the receivable, it needs to apply the rules in the PPSA for creating and perfecting security interests that we'll discuss in the next webinar. Next slide, please. Finally, then, in the 2 minutes I see that I have remaining, I'll talk briefly about operating leases, which is the second arm of the deemed security interest part of the definition of security interest in Section 3. Now, the model law and secure transactions does not apply to operating leases. Most other PPSAs, though, do, and I've given you just one example here, which is from New Zealand, but there is almost exactly the same language in all the Canadian PPSAs. We have a similar concept in the Australian PPSA as well. So the law will treat a right as a security interest if it's the right of a lessor under an operating lease for not less than 1 year. Again, you might ask why. Next slide, please. And here, there's only one primary reason given for extending a PPSA to operating leases, even though there's no security function in the transaction. And that's because it is often very difficult, if not impossible, to decide whether a lease is a finance lease, or sorry, the lease is in substance a security interest, or whether it is truly just an operating lease. The USA in Article 9 does not apply to operating leases. It only applies to leases that in substance give rise to a security interest. And that has generated probably 70 years of case law in the States of people trying to work out whether or not a particular lease is or is not covered by Article 9. Those cases have generated an enormous amount of jurisprudence about what are the factors that you apply in deciding which side of the line a particular lease might fall on. But despite all that, people still regularly go to court because it's simply not clear. And the approach taken in Canada, New Zealand, Australia, and in your PPSA as well, is that it's better to eliminate that risk by simply applying the Act to all leases for more than a year, so that you don't actually have to go through the pain and agony of trying to work out whether or not the Act applies. Now, the choice of 1 year as your bright line is a little bit arbitrary. We used to have 1 year for our law. We changed that a few years ago to say 3 years instead. Either way, the thinking is that most of the time, if you have a lease that runs for more than 1 year, it's probably going to be a security arrangement. So let's just make that clear by saying that they're all security arrangements. So it's not a perfect solution, but it's at least a clear one and provides certainty where there was uncertainty in the past. Last slide, please. I just wanted to finish with a question and an uncertainty. I'm sorry, despite having said that the objective of all this was to increase certainty, there is one aspect of the way your Act defines security interest which reintroduces a bit of uncertainty. I'm sorry, I misspoke there. It's not in the definition of security interest. Instead, it's in the definition of secured creditor. Now, clearly, security interest, the grantor of a security interest, and the secured creditor under a security interest are all a package of three concepts that need to be read together. And somewhat unhelpfully, your definition of secured creditor said it includes an accounts receivable buyer and a lessor under an operating lease, but only for the purposes of registration and priority. Now, the definition of security interest doesn't have that limitation in it. The definition of grantor doesn't have that limitation in it either. And in fact, the way those three definitions are structured is that they don't line up with each other quite as neatly as would have been ideal. But the outcome of this is it's not entirely clear to me, at least, what it means to say in the definition of secured creditor that it's only for the purposes of registration and priority, when you don't also say that in the definition of grantor or security interest. Now, most jurisdictions don't have that qualification anywhere. They all say, for all three definitions, that the rules in the Act apply for accounts receivable and 1 year operating leases, not just for the purposes of registration and priority, but rather for all purposes. So there's not much guidance you'll get from overseas, I'm afraid, on how to deal with that conundrum, but it is an uncertainty that's there. And I'm afraid I don't quite know how to deal with it. I think the safe approach would be to assume that all of the law applies rather than just the registration and priority rules, as that way it's better to be safe than sorry. If you follow all of the rules in the Act, then at least you know you won't get tripped up. So that would be my practical advice for how to deal with that conundrum is in a sense to ignore those words and just apply the entirety of the Act. I've run a few minutes over time. I apologise, but that's the end of my presentation. Thank you for listening, and I look forward to the question and answer session later in the seminar. Thank you.
Thank you, Bruce, for your very insightful and informative lecture. At this point, I would like to take this opportunity to recognize the presence of Mr. Jin Chang Lai, Principal Operations Officer and Lead for Financial Infrastructure in Asia and the Pacific, IFC Financial Institution Group Advisory Services, who brings extensive experience in reforming financial ecosystems across the region. May I invite Jin Chang to share some of his comments on today's discussion?
Thank you, Ellen. I thought you would speak before me. So, but okay. So, first, Bruce, on your last point about the definition of secure creditor. So, yeah, it does appear very strange. So, and I think the background is originally the law was made for nearly 50 pages, 50 pages. And then at the last minute, somebody say that some politicians say that, oh, this is too long, and then it had to be squeezed down to 21 or 22 pages. So in the rush to squeeze down, there were some mistakes making. So this is probably, I mean, one of the mistakes that was made. But this can be clarified in the later revised IRR. So there is an IRR, implementing rules and regulations. And this IRR will have to be revised at some point, not now because the market volume is not yet very high, but it will be revised sometime later. And then these kind of things can be clarified. So another major mistake that was made is that normally the law should clearly say that buyers in the ordinary interest of in the ordinary course of business of the seller takes collateral free of security interest, right? Because this is basically common sense. You go to a car dealership, you buy a car. As ordinary consumer, are you going to think that, oh, the car may be a collateral of some lenders? Not only banks. Normally, we don't really use the word bank. We normally only say lender because there are numerous non-bank lenders. And non-bank lenders should be strongly encouraged in any economy. So you go to a department store to buy a watch, you don't want to think that the watch is a collateral of some lenders, and you may not have full the right. So that kind of things should not happen. But somehow the law, at that point, in the last minute, it made some mistake. But hopefully, these kind of things can be, I mean, written into any commercial contract as necessary. So this is just a small comment on the last point. For each webinar later, my job is basically to bring some the business perspective or lending business perspective to the matter. I myself is not a lawyer. I'm not a legal person. I'm more like a policy worker, basically a banker, like a central banker. So that's my job. So for today, I only want to make 2 points, and I will share just 2 pages of slide, and then make the point. So please bear with me. And do you see my slide now?
Yes, but you have to make it larger.
Yeah, I'm trying. Okay. Okay, this is a work now. So point number 1 is because the audience are mainly legal people. The audience are probably not the lending business people. So not necessarily the lenders. So for the legal people, I would like to say that the space of movable asset finance or movables finance is super large. So in good markets, this should be at least 60 to 75% of commercial lending. So the focus is actually on commercial lending. For consumer one is mainly for purchase money security interest, which in the later webinar will talk about what is the purchase money security interest. So this is the number one space in commercial finance, means lending for the business purpose. So this is the way that I had constructed to explain what this space is about. So you have different assets, right? I only indicate some example, but there are other examples. So if you take receivable, then typically we say receivables finance. And if you purchase receivable, or if you take an assignment of receivable, then you will say factoring. And in terms of business area, also some major examples on the graph. So if you do receivable and supply chain finance in an organized way, by the organizing along the value chain, then it will be called supply chain finance. And if you use movable asset for infrastructure, it will be called infrastructure finance. And please remember, movable asset finance is the main way and almost the only way to do the infrastructure finance. This is something that people often forgot. People always say for SME, SME. Yes, it's for SME, but it's not only for SME, it's for everything in the economy. So if you issue a bond, whether short-term or long-term bonds in the capital market, often such an issuance is secure. It's normally secured by corporate receivable or by your loan receivable, lease receivable, factoring receivable, credit card receivable, or whatever receivable. So this is also hugely related to the capital market, and excluding the equity market, excluding stock exchanges. So, and there are three main methodology in this area, which I will not explain what they means. And we have many trainings from time to time. So you will learn from those kind of training. So the big idea you should get away is that this is the largest space for commercial finance. This is the main way of doing commercial finance. Commercial finance, the number one space is not to take, is not about land and building. The collateral, the main collateral is not about land and building. So this is a big idea for the legal people. Now, the second thing that I want to do is simply to use an example of where you can apply. So in any economy, you will have traders, producers, or whoever they are. These are the business entities that will have inventory. And inventory means taking out cash of the business. So typically, the business entity will need some financing. It may be they are exporting agri commodity. Then they will need to aggregate the agri commodity somewhere, normally near a port, and before they can transport it abroad in bulk, means in large quantity. And in the process, they will have to pay the farmers with money, with cash, but they will not have any income, right? Because they have not yet sold the goods. Even if they have sold the goods or commodity, they have not yet received the money. Typically, they will only receive like 2 months, 3 months later. So these kind of companies, they will always need financing. So one way to do it is through warehouse finance. Means the lender will lend to the goods stored in a warehouse. And these goods in the warehouse will be monitored or controlled by a third party. And this third party is called Collateral Management Company, or CMC. And internationally, there are two forms of contract. One is called SMA, means just monitoring. Another is called CMA, means the collateral management company will have a unique and exclusive control over the warehouse. So under this kind of transactions, where a lender hire a third-party collateral management company to help to manage and control the collateral for them, what kinds of law you should use? So somebody say that, oh, this is to apply the 1906 warehouse receipt bill. And I would advise that this is not the case. And if you do that, actually is to your disadvantage. The 1906 warehouse receipt law has many gaps. So practically is very difficult to use. And that is why so far in the case of Philippines, you do not have a real warehouse receipt finance market. This market does not exist. So do not apply that law. So there is a new effort by SEC to develop a new warehouse receipt law, and hopefully all of you can support it, and hopefully this new law will be approved soon. And I know that there are BSP and SEC officials in the audience, and thank you for joining, and you are most welcome to this webinar. So hopefully this new law will be approved. So, but in any case, even if the new law is approved, for warehouse finance, you are not supposed to apply warehouse receipt law. You are supposed to apply PPSA, because the inventory in the warehouse is simply a collateral. Normally, there is no need to write a warehouse receipt. Occasionally, or in some cases, in some countries, under CMA, where the CMC has a full control over the inventory in the warehouse, they can write warehouse receipt. But this is not mandatory. So sometimes they do it, but probably most of the time they do not do it. They simply treat it as a inventory collateral, not a title document like warehouse receipt. So the difference is between whether or not you have an inventory collateral or a title document. You are not lending against a title document, you are lending against the inventory collateral. So in that case, PPSA should apply. So the second big concept is that there are always third-party service provider in the space of movable asset finance. This may include collateral management company. It may include a third-party digital platform that will facilitate receivables finance, inventory finance, supply chain finance, or even financial leasing or whatever. And plus there are other types of third-party services provider. So for the lawyers in this audience, please bear in mind that in this big market, third-party services provider is very common, is a standard feature. It's not mandatory for every deal, but is very common in one way or another. So coming back to the case of warehouse finance, and in the PPSA, there is possession. So normally under the CMA, where there is a complete control, the collateral management company will have a possession of the inventory collateral on behalf of the lender. Under SMA, where is only monitoring, there is no possession. So this kind of concept is already in your IRR of PPSA. and it is under section, I think, 4.02. Again, section 4.02, and the wording that is used is called depository. Basically, depository means a warehouse, but the business language will be a collateral management company. So please bear this concept in mind, and there are already demands on these kind of services. They are already the service provider in the Philippines. One example is Control Union. Control Union is a multinational company that doing this business plus other business. So Control Union is already in the Philippines, and there are already lenders who are interested to do this business, but please make sure that you use the correct law. Do not go back to 1906 warehouse receipt law, which will not help you. And collateral management can be done by basically any warehousing company and any logistic company, and as long as there is some understanding and knowledge about what the business is about, they can develop these kind of services as an additional line of a product in order to get more income for them. But of course, they need to learn and they need to understand what the matter is about. So these are my comments or additional points, and I will pause here and then hand over the floor back to the Eileen. Thank you.
Thank you, Jin Chan. As we know, the PPSA and its implementing rules and regulations took effect way back in 2019, and the passing of the law has greatly changed the landscape of secured financing for personal property in the Philippines. While in the previous regime, personal property could generally only be secured by means of a pledge or chattel mortgage, substantive requirements for the constitution of a pledge or chattel mortgage existed, which limited the nature of movables subject of a security interest. As an example, under the previous regime, future property could not be subject of a pledge or chattel mortgage because the law required that a party cannot legally pledge or mortgage property he does not yet own, with the exception of after acquired property in renewal of or in substitution of certain goods, which under jurisprudence was considered covered by the original chattel mortgage. Another example would be the case of receivables, whereby an assignment of receivables by way of security under the previous regime had been structured as a chattel mortgage, which required the grantor to identify the specific receivables and update such mortgage over receivables through mortgage supplements. Moreover, while the previous regime allowed for a diverse set of personal properties to be subject of a chattel mortgage, including in particular for micro, small, and medium enterprises, agri-aqua commodities like standing crops, rice, and sugarcane, these types of personal property were not being fully utilized, preferred, or accepted by lending institutions as collateral. With the passing of the PPSA, the ease of constituting a security interest over a wide variety of assets has provided these lending institutions an avenue to expand the acceptable types of personal properties, which can be subject to a security interest, including, as what was mentioned earlier, movables such as future after acquired assets and receivables, which have been expressly recognized under the PPSA. Collateral was also allowed to be described generally and generically, with the creation requirements for a security interest being kept at a minimum. In addition, and more important, with the fairly recent full operationalization of the Personal Property Security Registry, or the PPSR, last February 2025, the non-burdensome registration fee required under the law has been implemented. Under current regulations, the registration fee for the registration of personal property in the PPSR is set at 380 pesos for the registration of a new notice and 30 pesos under the registration of the amendment notice. This is a very substantial reduction from the previous schedule of fees ranging from 21 pesos to 8,796 pesos for amounts below 1.7 million, with an additional 90 pesos for every 20,000 pesos in excess of 1.7 million, which, if added up, can run into millions of pesos for large value secured amounts. We will discuss this further again during the next webinar sessions. Hopefully, with the reforms introduced by the PPSA and rollout of the PPSR, the secured finance regime can transform and, in line with the goals of PPSA, allow MSMEs easy and effective access to financing. So at this point, we would invite our participants who may have questions on this morning's session to send your questions through the chat box so we can start with our Q&A session. However, before that, I would like to take this opportunity to again thank Bruce and Jin Chang, who have been instrumental in bringing into fruition this webinar series, as well as Ms. Lin Wang and Eileen Makalintal from the IFC, who have supported the planning and execution of the series. We would also like to thank again the many esteemed institutions and clients joining us today. Your presence and participation are much appreciated. So moving on to our Q&A session, where we invite Bruce and Jin Chang to address your queries. We received some questions in the chat box. Allow me to start off. For land leases, how strong is the PPSA in addressing interest like leases, which may fall between real property and personal property?
I already provided some written answer to question number one. So is probably some confusion with the immovables lease. Occasionally in some country, when they say financial lease, they include like the housing lease, building lease, this kind of thing. But this is not very common. So personally, I think those should not be included. So, but let's remember, rental receivable is a receivable. It's very common for movable asset lender to lend against a rental receivable. I'm in Mumbai, India, and near my home there is a bank. So outside the branch of the bank, there's a big advertisement some time ago about using about rental receivable as a collateral for SMEs. So that's an example. But I over to you, Bruce.
No, that's right, Jin Chung. Whether the Act applies to a lease of immovable property will ultimately be determined by how you interpret your civil code to decide whether the rights of a lessee of lands are immovable, is an immovable property interest, or whether it's a movable property interest. And so in one case, the PPSA won't apply, and in the other case it will. So that answer really lies outside the PPSA itself and is part of it's a question of more general Philippine law.
I think that's correct. In relation to land leases, normally this would be annotated in the titles for the existing immovable property. For practical purposes of enforcement, they would consider that as the manner of enforcing these land leases. So the next question would be, is factoring covered by the PPSA under a deemed security interest?
So factoring, yes, absolutely. Well, factoring is a commercial term, not a technical legal term, but by factoring, I take that to mean acquiring receivables or acquiring an interest in receivables as a financing transaction. And if that's what's going on, then yes, the law will apply.
Okay, the next question would be, what are the best practices for perfecting security interest over accounts receivable, especially factoring arrangements under the PPSA?
Well, we'll discuss this in more detail, I think, in the next webinar, but best practice would be to register a statement in the registry that covers the receivables that you're proposing to finance. That would be in fact, that's almost the only way you can perfect a security interest over receivables.
The next question, will PPSA still cover outright sale of accounts receivable even if it was without recourse sale?
My understanding is yes. That's the second. That's the leg. That's the deemed security interest leg of the definition of security interest. So yes.
Yeah, okay. Here we are discussing about legal things, right? So for the receivable, whether is you simply take security interest over receivable, or you take an outright transfer of the receivable both will need to be registered if you want to establish a priority against any third parties, or in other words, if you want to perfect the security interest. It's a standard practice in any market without any question. This has nothing to do with recourse or non-recourse. In factoring or receivables finance, there are many details, I would say, with collection, without collection, with recourse, without recourse, and whether or not you manage the ledger or not manage the ledger, all those are just business details. But legally, you simply has a security interest over the receivable, and this security interest must be registered if you want the higher priority.
Yes, thanks, Jin Chang, and thanks, Attorney Recalde has also given his comments on that. I think that's why, in terms of the registration of receivables under our current regulations, there is a requirement that it be in the agreement, because I think the intention was to address these types of receivables without recourse, or these types of receivables which are considered as outright sales. Okay, the next question would be, how robust is the PPSA's protection of perfected security interest in the event of a debtor's insolvency or corporate rehabilitation? Are there any specific provisions that need careful attention from creditors?
I can speak to that one again and again. This is something I will delve into in more detail in, I think, the third webinar or the fourth webinar. But the short answer is in section 22, I think it is, of the Act, which says that as a general principle, if you've got a perfected security interest, then it will retain its perfected status and it should retain its priority, even if the grantor becomes insolvent. But that's something I will dig into in more detail later on. That's certainly the starting point. And in fact, that's the point in time when you most need your security interest to work. If your borrower is solvent, then security is kind of sitting here in the background but doesn't have a great role to play. It's really when they are unable to pay their debts and they go insolvent, that's when you really want your security to work. And as a starting point, that's what section 22 says.
Thank you, Bruce. So the next question would be, is written notation in the security or share registry of the issuer deemed effective perfection, even if not registered under the security registry? Under the priority rules, we recognize written notation in such security or share registry.
That's a question I might need to take a little bit on notice, because we'll be talking about perfection of security interests in the next webinar. But I think you do have a mechanism in the Act for perfecting by control over securities. Honestly, at the moment, I can't remember whether that includes notations in the share registry or not. But so if you don't mind, let's save that question for the next seminar.
Yeah, I hold on. So yeah, I think it looks like maybe, I mean, it's non-traded company shares. So in the old ways, because Philippines obviously had the old regime, the old way until recently, is that there is a company registry, right? And then if you take the company shares, so you will put a notation with the company registry. So that's the very old civil law, the country's way, continental the laws way. Again, I'm not a lawyer and a banker, so but this is very common in those countries. But remember, under PPSA, for those kind of things, you will still have to register in the collateral registry in order to make any existing and prospective creditor know that you have the security interest over a company's share. Otherwise, with all this little registry, a creditor will have to search on multiple and multiple of registry. This will confuse the market. So this should be registered. But Bruce will come to it when it comes to this point in the later webinar.
Yep.
Okay, just to add, I think in relation to shares of stock, for which we will discuss again in the next series of webinars, the mode of perfection for shares of stock would actually be possession, and the notation in the stock and transfer book was more in line with the ensuring that the company itself is put on notice in respect of the registration, precisely, Jin Chang, because of the notice. It will not be part of the notice requirements under the registry. So yes, to enable the whole world to know, or the public to know, of this type of security interest created over shares of stock, notice will have to be made via registration in the PPSR. Next question would be, can future property be used as collateral under the PPSA? I think the answer would be yes. And the next question would be, the PPSA registry portal, particularly for receivables, is not functional at this time. Can receivable security still be used under the PPSA law?
Yeah, that probably I need to answer. So first, I don't really understand the question. I'm sorry. So this had to be answered by LRA, but conceptually, this is not possible. Let me say again, it's not possible. Why is it not possible? It is probably because of some misunderstanding. So in a collateral registry, you only need three information: the identity of the lender and identity of the borrower, plus a brief description of the receivable. So whether or not receivable security interest is can be registered or not, it only concerns the brief description. The brief description has a small box in a normal collateral registry where you describe something. You may simply say any existing and future receivable, and this is good enough. Or you may simply say receivable from such a day to such a day, or receivable due from a group of buyers or whatever. So this depends on what you are going to put it in the brief description. So how come receivable is not possible to be registered, receivable security interest? So I don't understand the question, and normally conceptually this is not possible. But having said that, I don't know the details about your new collateral registry. So not sure what is the issue behind, maybe some misunderstanding. It is new, of course, please give them some time to improve the collateral registry. There's always a teething problem with the IT system. Now, let me also say, such an IT system, super simple. For IT people, is a no-brainer. So it's not a complicated thing like credit bureau. No. Super simple, easy thing in terms of IT system. But give them some time to improve.
Yes, I think, Jin Chang, because in the PPSR, there appears to be, while you can make a general description as intended under the PPSA, there is some drop-down tabs that will have general description of the more general asset types. So I think maybe that would be some of the issues concerning, in respect particularly of the receivables.
Yeah,
There,
hold on, that's correct. But that is only for statistics purpose. And in this drop-down menu, normally the number one item has to be receivable. Because receivable is most important. Normally it has to be receivable, inventory, equipment, company share, whatever, such a drop-down. And then at the end of this drop-down menu, it has to be others.
yeah.
It means anything that's not in the previous listed item. So this is the way, and we actually have already made some suggestion, but I don't know what's the reality today. So I'm sure LRA, they will make the necessary improvement and they understand the matter, I'm sure.
Thanks, Jin Chang. There's quite a few questions on receivable financing and loan receivables, so maybe I'll just read them. There's a difference between sale and loan under our laws. Please comment on the effect of PPSA on receivables financing. In the definition of accounts receivable, this excludes financial services, so we presume excludes loan receivables from a borrower. Given so, are loan receivables assignable?
Okay, I can start with those. On the first one about the fact that your traditional legal thinking quite understandably distinguishes between a sale of receivables and a loan secured by receivables. Yes, this is one of those examples of a situation where, unfortunately, we need to put aside the traditional way of conducting a legal analysis of arrangements and instead just apply what the definition of security interest says. And the short answer is that while there was a distinction between an outright sale and a security sale under your prior law, there is no distinction of that type anymore under the PPSA. It applies to both of them in much the same way.
Yeah, Bruce, if you look at the receivables definition under IRR, is I think is page 4 under IRR. So I don't know why people say that loan receivable is excluded. To my mind, is not excluded. So it's clear. It says receivable means a right to payment of a monetary obligation. Then comma is simply a monetary obligation, excluding a few things, which is very common. So if receivable is already evidenced by a negotiable instrument, then negotiable instrument law will apply. It is not a receivable. This is very common in throughout the world. So plus other regular things. So then loan receivable should be included. So I don't see anywhere that it will be excluded.
Thanks, Jin Chan. Okay, on the next series of questions, what are the practical implications when there's a dispute over priority, and how is it typically resolved under the PPSA framework? I think this is also something that we'll be discussing in the next webinar series on enforcement. Can a security agreement simply use the definition over all personal properties and then allow the creditor to chase after any of the lessor's personal property that might be known to the creditor?
Yeah, I can start there. It's absolutely possible to have a security agreement that says that the grantor grants security over all present and future personal property. Certainly in a corporate context, that's a very common way of structuring security arrangements, and that works perfectly well under the PPSA. And yes, if the grantor has agreed to give you security over all of its present and future property, then if the borrower defaults, then yes, you can pursue that property in order to recover your loan, provided you've perfected. So absolutely, yes.
Okay. Are assignments of accounts receivable subject to mandatory registration under the PPSA? If so, is such registration required to be made on a per assignment basis? Assuming registration is required, can the notarization of the assignment agreement be waived? In relation thereto, there are a lot of questions on receivables. For receivables, there will be a need to upload in the PPSR system the list of receivables. If yes, and if the security agreement requires the borrower for monthly updating of the assigned receivables, will it be required or prudent for an amendment to the initial notice be made to upload the updated list of receivables? Are loan receivables under the PPSA already a standalone and not a collateral? Hence, if loan is invalidated, the PPSA agreement is voided.
Okay, a lot of these questions are ones that we'll be digging into in more detail in later webinars. And I'd prefer not to sort of give a half answer now and rather give a more complete answer later on. But just in relation to that first question, I would say that registration is not mandatory. You don't have to register, but there are obviously adverse commercial consequences if you don't. So certainly absolutely advisable to perfect by registration. And also you do not need to register each assignment. You do not need to register each receivable. You can use a more generic description to you could just say receivables or receivables owed by a particular borrower. You do not need to describe each receivable. if you did need to describe each receivable, it would be impossible to do a registration that covered future property because you don't yet know what the future property is going to be. So you can absolutely use a generic description in both your security agreements, potentially, and absolutely in the registration.
Yes, I think there's a lot of interest in receivables. As I mentioned earlier, it was previously under the previous regime something that was not allowed under our laws, and that we had to do it as a chattel mortgage, and that is why they are mentioning the listing of specific receivables on an as and when basis, that there is new or present receivables that can be subject of a chattel mortgage. So again, the enforcement of security interest over receivables is something that a lot would be interested to hear in the later parts of the webinar. We have a few. Go ahead, Jinsha.
Yeah. So, yeah, I understand that the legal people may not be familiar with the use of receivable because of the old regime. In the very old civil law countries, typically the mindset is that okay, every collateral you have to be listed, specifically identifiable, specifically say what it is to the maximum extent possible. But this kind of concept does not apply in the modern economy, in the modern society. So if you have to do that, then the economy will be seriously affected. So in terms of receivables, most of the things will need to be sorted out through the business training. Is not really a legal training. So there are very mature business ways of handling all these things. Once you understand the business way, then you understand why the law is like that. So there's no straightforward answer to all those things. But yes, receivables interests are normally always registered. It is not mandatory, but any sensible lender will do that without any question. So, and there are many products under the receivables finance space, whether it's factoring or not factoring, whether it's outright transfer or simply a security interest or whatever. So do not think too much about it. Receivable finance is actually quite easy. So, and is the most common way to do it. So don't worry too much about enforcement because typically buyer will have to pay the money. Receivable is there's a seller and buyer, right? Buyer will pay the seller to a specific account, and the account is monitored or controlled. You simply just deduct the money from the account. So this is just a brief description for you to have confidence that this is a very easy way of doing things. In terms of description, there are also simple ways to describe. You don't need to list down every single receivable with all the details, except if you have a large receivable assignment for maybe a seller of a turbine costing $50 million, $100 million, or whatever. So it's up to you how much you want to describe. So these are just some flavor, but supposedly we will organize some business training, and some of you can also join. And if any of you want to organize some training, this also can be discussed. In normal country, we actually organize with banking association, financial association, and how to do it in Philippines. I mean, if you have a way to do it, we can consider, but not mandatory. Thank you.
Thank you. Okay, so we're going to have our last few questions because we're pressed for time. On the question on if a security agreement includes a general clause covering all present and future personal property of the borrower in case of default, does this eliminate the need to file a separate collection or sum of money case to recover the loan amount? Maybe we can discuss this in the latter part on enforcement. So the last two questions, are cryptocurrencies and digital assets deemed personal properties in other jurisdictions that can be collateralized and made subject of a security agreement? In connection with this, how would the security interest be perfected and documented if it is held in self-custody or stored in an exchange? And is cash or money subject of PPSA?
I might start with the easy question, and that is the one about cash or money. It's personal property. So yes, cash or money can be the subject of a security interest under the PPSA. So that I think is pretty clear and pretty straightforward. The question about cryptocurrencies, I'm afraid, is well beyond my skill set to provide a good answer to, because I know there are very clever people all around the world who are constantly trying to work out exactly what cryptocurrencies are. Are they a species of property in their own right? Are they simply a representation of a bundle of rights you might have against the operator of the cryptocurrency system? There is, to my knowledge, no clear answer or no settled view on that yet. So I don't know that there is an answer. My instinct tells me that there's a property right of some sort in there, but exactly what it is and where it is and who owes it to you, I don't think the world has answers to those questions yet.
Yeah, the general answer is number one, digital asset certainly is a movable asset. You can take it as a security for lending. In some countries, they are already doing it, but this volume is not very high. So second, for the Philippines, this is not your priority. Your priority is to take general movable asset as collateral, particularly receivables and inventory. This had not yet been done in wide scale. So those kind of fancy things is not a priority. So, but if we want to do it, most welcome. Number three, for the digital asset is just like warehouse receipt, right? So to control it, there is a way to control it digitally in the IT system. And digital control is a control. So it will be considered as one way of profession and their definition of what is a control in the digital system. And this is not difficult. In the US, they have this definition since the 1990s. And you can easily search for it. What does it mean by control in the digital system?
Thank you, Jin Chang. Okay, so it's already 10:50. We are now at the end of our webinar series. Again, allow me to thank Bruce, Jin Chang, and the entire IFC team, as well as the participants for your time and participation. For some closing remarks, may I again call Jin Chang?
Thank you. I did not realize I need to do closing remarks. So, and I think there's not much to say. So, and I'm very grateful that today there is a big turnout of audience. I think the highest number of participants is 325 or 326. And that's a kudos to our gracious host, ACCRA Law. So that so many people turn up, and then Elaine is now the most famous person in this area now, and thank you for that. And thank you, Elaine, and thank you, ACCRA Law. Thank you, Bruce, for taking the time to study all the Philippine documents, and then started to do some legal webinar here. We are very grateful for that. And we are all very grateful for all the participants, particularly from the government institutions and regulatory agencies. So I would like to say that this is something relatively new. So be patient with the market, be patient with any regulatory agencies. This kind of market, it will take some time to develop. And after a few years, when you try a few deals, you will actually understand it very well. So no worry about it, be patient, and do not hand over any difficult question or whatever. Eventually, you will get the answer, or you will realize it yourself if you do a few deals of why the law is that way and why the transaction had to be structured in a certain way. And we have been organizing some trainings in the past 2 to 3 years, and we will try to do more. And I think I will pause here, and then let's look forward to the next webinar. I think more or less the day is already fixed, right,
Yes,
Ellen?
yes,
So
Jin Chang.
you may want to
Yes.
say.
All right. Thank you again, Jin Chang. Bruce, it's been a pleasure spending this very informative Friday morning with everyone. We look forward to seeing you again at our next webinar series. It will be held on August 15, same time, 9 a.m. to 11 a.m. As a final note, Mr. Francis Garcia of ACCRA Law will be sending out some feedback forms to your emails with reminders on the next webinar series. We would greatly appreciate if you could spend a few times to answer the forms. We know there are some technical difficulties in terms of continuous collection, and we'll try to address that in the next webinar series. So thank you, everyone, and we hope you enjoy the rest of your Friday.